Welcome to Family Law Practice, week 1 of term 2. Basically, I will be passing through this workshop to give you a highlight of what you should expect next week. Please, if you have not subscribed, consider subscribing, because on this YouTube channel, we analyze all the workshops from both intakes and also give you tips on how to pass your oral exams. So if you want to pass your oral exams, just subscribe, like, share, and comment. Then absolutely you will not miss any update when we are giving you tips on how to pass oral exams. So this workshop deals with estate planning, probate, and letters of administration. So the first module dealt with marriage, separation, and resolution of marriage. The second module dealt with matters of children. The third module is succession, estate planning, probate, and letters of administration. So basically, when we talk about probate or grant of probate, is when a person dies with a will. But when we talk about letters of administration, it basically means that the person had no will. So you have to understand these two terms at the very beginning. Grant of probate means the person left a will, and then you are proceeding to court as an executor to get the will. Whereas letters of administration, it means that the person did not leave any will. Then we shall also look at, of course, tested and intested. Tested succession means that the person left a will, whereas intested succession means that the person did not leave any will. So this module introduces you to practice aspects of estate planning, testese and intestese. So the importance of relevance of this module cannot be underscored. The disadvantages of intestese are obvious, and yet a will alone, although varied, may not always be adequate estate planning. So the value of estate planning cannot be overemphasized, because fraud is a way of life today. So administration of estates of the deceased cannot be trusted to work in the best interest of the beneficiaries of the estates which they manage. Many of them do not even know that they are trustees of these estates. So basically, when we talk about estate planning, we mean how the estate of the deceased, or maybe the property of the deceased, is managed. The first time I heard about estate planning, I thought they were going to teach us about real estates, how to buy and sell properties. But that's not what it means. When you talk about estate planning, is how is your property going to be managed after you have died. So we are saying that the courts have dealt with a very big number of cases involving negligence, waste, fraudulent dealings, and management of estates of deceased people, and the other courts can only do so much: uphold caveats and revoke grants. Judgments and decisions of court will not always ensure recovery of property stolen or wasted or lost. Therefore, it is the beneficiaries of these estates who stand to lose. The situation is terrible where the beneficiaries are children or totally dependent people, like the elderly and incapacitated people. The need provides for the surety of one's estate, the livelihood of one's children and dependents after one's demise or disability, or in the event that the person goes missing, requires intentional planning for one's property and affairs. Estate planning, this can be achieved by using the strategy of a will or trust, or both, depending on, or among others, the size of one's estate and the complexity of his affairs. A vast business empire or polygamous family may not be adequately planned for by simply writing a valid will, even if it creates a testamentary trust. So basically, here we shall look at a trust, as well as how do you make a will. So whereas you should know the principles of law on testese and intestese, and also learn the skills of preparing a valid will, obtaining probate and letters of administration, and protecting these estates, as well as the interests of the beneficiaries of these estates, it is imperative that you learn the skills of estate planning. You should know the principles of law on estate planning and be able to apply the knowledge to each unique case, and accordingly effectively advise people on how they should plan for their property, for their benefit, intervivors, and the security of their estates, as well as the welfare of their loved ones or dependent in case of their demise, mental illness, or their disappearance. The trust deed must be strategically prepared so as to be able to deal with your client's unique situation, simple or complex. You should be able to determine the strategies which are ideal for your client's unique case and design them carefully in order to resolve his or her unique problem. So we shall basically be looking at trusts, creating of trusts, as well as wills. So the scope of this week's work: prepare of law relating to principles of law relating to estate planning, intestacy, and intestacy, using the will and trust as tools of estate planning, nature of estates of the dead, testacy and intestacy. So basically when we talk about testacy, that means that the person left a will. Intestacy, it means the person did not leave a will. 4. Determining beneficiaries of estates of the dead and the rights of these beneficiaries. The procedure and practice of obtaining probate and letters of administration. So probate is when a person left a will, letters of administration is when a person did not leave a will. Presenting and prosecuting a petition for probate or letters of administration. So we shall look at this in the mood. The procedure for lodging a caveat upon an application for probate or letters of administration. Suits arising out of caveat lodged upon an application for probate or letters of administration. So suits arising out of a caveat lodged upon an application for probate or letters of administration. So we shall see the suits now which arise out of a caveat lodged upon an application for probate or letters of administration. So defenses suits arising out of caveat lodged upon an application for probate or letters of administration. So the procedure for probate proceeding. So when we talk about probate proceeding, is basically when you sue a person. For example, you get letters of administration from Kenya and you want to apply them to Uganda. That's what we call probate proceeding. So it's a process which we shall look at, but in simple terms, just know probate proceeding applies where you have letters of administration from Kenya and some of the properties are in Uganda. So drafting all of the documents such as will, trust deed for the objectives of estate planning, a petition of probate, petition for letters of administration, the caveat to be lodged against the petition for probate letters of administration, and the relevant court documents, etc. So extracting and enforcing the relevant orders, ESCO considerations in these areas of practice. So basically the statutes we shall be having the Constitution, among others. The case says wills. Of course, wills have been defined. The case of Banks versus Goodfellow as a testamentary document passing property from a person to another. But then the case of Banks versus Goodfellow also is a locus classicus on conditions or the elements for one to be able to make a valid will. Of course, you must have capacity to contract or to make a valid will, and also you must be depositing your own or bequeathing your own property in that will. But the case of Banks versus Goodfellow, because remember what was examined in that case was whether the person had capacity to do what, to make a will. Then we shall look at what the testator can and cannot bequeath. Of course, James Chamukaman and another versus Catherine Zarbuendo, you cannot bequeath a property which you do not solely own. For you to bequeath a property, you must be the owner of that property. Beneficiaries, meaning and determinants. Of course, beneficiaries, we have seen that they have the right to sue now in case the estate is being deprived, and they have, of course, they are entitled to the estate. The nature of office and powers of administration or executors. So Florence Sari, the court is saying that the administrator is supposed to pass the property to the beneficiaries. Then powers of administrators to administer jointly the estate, that's Silva Biarhanga. Suppose having separated from the intestate as at the time of death of the intestate. So intestate means the person had a will. So if you had separated, always the law is that you are not entitled to any property, according to Narmas Elizabeth versus Jory Kasande. Then what testator can and cannot bequeath, we have looked at that caveats. You can lodge caveats on the opposing the grant of letters of probate or letters of administration. Then administration pendulite, these ones arises, for example, where you find that the letters of administration have been revoked and there is no person managing the estate. So during that time, the court will appoint whom we call administrative pendulite. And for that, look at the case of Tayebwa versus Chotwaha. Then extensions of validity of probate letters of administration. an application for renewal of letters of administration in respect of the estate of the late, then extension of time within which to file an inventory. Of course, after 6 months, you must file what we call an inventory, which basically has all the properties of the deceased. Disputes relating to burial of the deceased and what court consider. Here we are looking at where should you bury the deceased, because of the recent, these ones have also come popular. People are fighting over where to bury the deceased. Then trusts, we shall look at how do you create trusts basically for family, like the way we have seen above. Then workshop 1, we have my name is Sarah Tete, my students are Lona, Basima, Lambert, Mpongobga. Their father died 2 years ago. Lona is a student at Mbara University of Science and Technology. She's married. I am a very strong support of and sponsor of Alliance for Political Reform. I would like to advise on how best to ensure the well-being of the children and parents in case I die. So I own the following property: a milk processing plant at Mendo in Usoro. I practice crop and animal husbandry. I also manage ultramodern hatchery. Shares in Denzo Creams Limited here, and also see other properties in district in Chizongo in Wikwe district. I also see Jaguar Bus alongside other properties, Bukoto Guest House. My 86-year-old father is suffering from dementia. I live with and look after my mother. Then after my death, I would like responsible and honest people, my brother Nixon Ntari and my sister, to hold and manage selected properties of mine for the benefits of my parents. So basically that's where we are going to create a trust on these basic properties. That's why you create a trust. These properties have land in Tinder, modern and popular grocery, among others. So I trust my brother. So task A, advise Mr. Odinda on what constitutes Sarah Tete's estate, who qualifies as beneficiaries of her estate, and the rights of these beneficiaries. So basically here what you shall be looking is at the property which Sarah Tete owns as an individual. Here I've seen land, Jaguar Bus, among others. Then the beneficiaries, we can see the mother and the father whom she was taking care of, then among others. So their rights is that they are supposed to benefit from the estate. Then advise Mr. Odinda on all the practical steps which Sarah Tete should take in order to ensure that if she should die, her dependents will be assured. So basically here you can create a trust, because we saw where he wants a property to be held in trust for the benefit of the parents. That one you can create a trust there. But also you have to make a will so as you can bequeath your estate to the beneficiaries. So prepare a checklist of the information you require from Sarah. So basically this checklist is going to give us adequate information to draft a will and also a trust. So assume that Sarah Tete died having executed a valid will. Advise her family on the steps which they should take in order to ensure that her estate is managed lawfully. So basically here what we are looking at is the process of applying for letters of probate. That's what we shall be looking at. How do you apply for letters of probate? Then the relevant documents, we shall look at petition, notice of application, and administrative bond. So those are the documents we shall be looking at for applying of letters of probate. In Sarah Tete's will here above, she did not make any provision for the maintenance or any benefit for biological son Lambert, on the ground that he became a born-again Christian and stopped worshipping the Catholic Church at Westminster. Odinda, in the regard of this position, the remedies, if any, available to Lambert, and how you will obtain the same. So basically here we are looking at the position of the law is that your father or maybe your mother is not entitled to give any property to you. But where this has happened, then if you can prove that you are relying on him or her, then you can apply to court and then you can get a remedy. So we shall discuss the procedure. How do you basically go for that? So the ESCO issues, would you consider? Of course, ESCO issues, we have a lot of ESCO issues. One, confidentiality, not overcharging your client, among others. Of course, also the best interest principle. All matters to do with children, you must consider what is the best interest of the children. So basically that is the analysis of workshop 1. I believe that I have given you a sketchy highlight of how you can begin your research because it's better that you know what to do. Knowing what to do is one thing, and knowing what not to do is also another thing. So, but in case you need a mentorship, maybe you need notes, or maybe you need to have a mastermind group from all campuses where we have students. We analyze all this workshop on Saturday, and then immediately we give notes, comprehensive notes. So in case you want mentorship, because even the best player needs a coach. Cristiano Ronaldo has a coach, Messi had a coach, Beckham had a coach. So you really need a coach, but that's only if you can afford to pay for one. But if you cannot, still I understand. I'm still here to guide you. So if you are interested in that, please you contact me on the number on this YouTube channel. Then I will members in our mentorship group pay a monthly subscription fee. So let us proceed to workshop 2. By the end of this workshop, you should be able to explain the principles of loan intestacy, determine the state of an intestate, the beneficiary thereof and their rights, demonstrate the procedure and practice of obtaining letters of administration. So intestacy means that the person didn't leave any will. Letters of administration basically means that the person didn't leave any will. Present and prosecute a petition for letters of administration. Demonstrate the procedure for lodging a caveat upon an application for probate of letters of administration. Demonstrate the procedure for probate receiving, and draw all the relevant legal documents. Identify an appropriate deal with the ethical issues that they may arise these areas of practice. So my name is John Asimwe. I live at Sonde in Waxo district. My husband who died in a car collision. We left me with the children. I started living with my husband in 1998. In that year, he paid all the bride price with my parents asked for. I hail from Bushenyi district. My husband married Margaret Birungi at Naminembe Cathedral. My husband told me that he raised Samiro Birungi, now aged 12. My husband told me that he had a lot of suspicion that he was not the father of Samari. My husband took Samari Birungi for deoxynic acid. Those results proved that he was not Samari father. He had another test done. I came with a bag which contains very many valuable documents, including his marriage certificate showing and any reports. So my husband left the following property: a residential house at Kaoku and Tebe Road, where he used to live with his first wife. Then we have a residential house at Sonde, Maize Mill, modern commercial building at Tukumba, and further the property which forms the estate of the local Simbi, the beneficiary said estate and their rights. So basically here you look at also what are the properties we have looked above, and basically who are the beneficiaries. So the question would be whether this person who is not his father is he a beneficiary or not. Of course, we shall have to look at the law, but once he has been taking care of him for all these years, then that means he or she can be a beneficiary. But that's a question of really debate. We shall then see whether he qualifies to be a beneficiary or not. Then 2, what steps should the beneficiaries of his estate take in order to lawfully manage his property without seizure? So basically here, the fact that we had no will is going to apply for letters of administration. So what additional information and evidence do you need in order to efficiently advise the right of beneficiaries of this estate? So here you are going to ask information about these people, because remember, for you to apply for letters of administration, you need to do what? You need to call a family meeting. You get, so it's going to be a third process where you're getting even certificate of titles from these documents and all other things, and who is supposed to be the executor. Then assume that you have obtained all relevant information, draft the necessary legal documents which will enable you to obtain the instruments. So basically here it's also a petition. We shall proceed by a petition to get the letters of administration. Explain the procedure and practice of obtaining the requisite grant. So basically here we're looking at a procedure of getting the letters of administration. You have to call family meeting, keep minutes. Then after you apply, which we shall also look at. Then B, supposing that the estate of Luca above were worth 45 million Uganda shillings, what procedure steps would you advise the person who is entitled to administer it to take in order to administer it roughly? What would be the necessary legal documents? So basically how we have to go into the management of small estates. We have small estates, the administration of small estates, Act 263, the administration of estates of small estates, Act 263, and then that's where we're going to be proceeding from. Just look in there, they have the procedure as well as the documents in that act. My name is Lucia. I am 48 years old. My sister, the late Suzette, died in nasty car collision. She has 3 children. I live with Sarah and Alice. I'm their guardian. Sarah is a student of medicine at Macquarie University. Alice is a senior C at Nabugongo. Their father died before their mother. Mr. Lawyer Amos Mugezi took me to several offices as well as the High Court. I have brought a photocopy of the document which the High Court gave me. Refer to document labeled LC. There is so much I have not done. I must sue the man who stole Suzette's 100 acres of land. Plot, and I am glad I have obtained all the evidence which I need. It has taken me over 6 months to assemble this evidence. I must also sue the government of Uganda because my sister supplied foods 5 months after the death of my sister, Miss Aguera Camacho. I want to know the withdraw 50 million Uganda shillings from Suzette's saving bank account. I must recover this money as well. My nephew and nieces have no complaint against me whatsoever. They would like me to recover his property and money. So I think LC5 is the grant of letters of administration. LC, the document referred to LC, but we shall look at that. Here we see Lucia Rutara, sister, and then we have the grant of letters. So they are asking advise Lucia Rutara on the steps which she must take in order to ensure that she recovers the money and the land and all the necessary legal documents. So basically here, for what this research is going to do, first and foremost, she can lodge a caveat on these titles, because always what happens is after the grant of the letters of administration, you are always supposed to do what? To file an inventory. But then this was not the person who was granted letters of administration, as we shall see in document labeled LC. So now if he wants to challenge how those letters of administration, basically, of course, you have to you can lodge caveats on those property, and then you can proceed to do what? To challenge the grant of what? Of the letters of administration, and the document would be a plaint. So advise will see on the steps which she must take in order to ensure that he recovers the money and the land and all the necessary legal documents. So D, I am Musa Musango. I'm 60 years old. I live in my retirement home at Chegoba, Masaka. I decided to leave my home at Runguja. When I was reading Wicked, the newspaper, I was extremely shocked to learn of the notice at page 15. So this one, the notice of grant of letters of administration, and I own the foreign property. So basically, what this Mzee can do, what practical steps will you take in the interim on Musango's behalf? You lodge a caveat against the granting of the letters of administration, like the way we have seen. Draft necessary legal documents. Where will you file these documents? So these documents are filed at the registry of the court that issued this notice. So it's now 3 months since you took in the steps in above. You have confirmed that the petition in M2 has not taken any step in the matter. What further steps would you take in Musango's behalf and do the necessary documents? So basically here, you can also, I think you proceed by a suit to challenge the what? Challenge the petition. So D, supposing that Musa Musango's were instead worth 40 million Uganda shillings, what practical steps would you take in order to protect his property and draw the relevant legal documents? So basically here we are proceeding under the Small Estates Act. So that's why we have to go for part D. So part F, Dr. Celine Waika was a Kenyan. She was working in a senior lecture. So basically here in part D, since we have a Kenyan, what we do is we have to go for probate sealing. We have to go for probate sealing because I told you once you have an international and you obtain grant from an international country, you go for what we call probate sealing. So basically that is it, highlight of what you should expect next week. But in case you have you want a detailed discussion on those tasks which I was not clear about, because we have not made adequate research as a team, but tomorrow we shall be ready to delve into the law, the cases, and the necessary documents, so as you can benefit from the same. But I believe also, if you can't manage our mentorship mastermind group where members pay a monthly subscription fee, still this discussion has been good for you. So let us proceed to pass through workshop 3. By the end of this month, you should be able to draft pleadings to a suit arising out of a caveat lodged on application for probate or letters of administration. Draft pleadings for a defense to a suit arising out of a caveat lodged on an application for probate or letters of administration. Present and prosecute a suit arising out of a caveat lodged on an application for probate or letters of administration. Present and prosecute a defense to a suit arising out of a caveat lodged on an application for probate or letters of administration. Recognize and appropriately deal with ethical dilemmas that may arise in prosecuting instructions in the area of practice. So, facts of Mera Bankunda. My name is Mera Bankunda. I live in Chamugorani, Mbarara City. I work as a security guard. I am the biological child of Asimwe, who died on 7th. My mother had 2 children, my brother Chrisma. My mother was married to Dick, but they have had no children. We have Solomon. Dick has applied to the High Court Mbarara for authority to manage my mother's property. I have read the notes of his application on today's Oromori News. I do not trust Dick. I look after my brother without any contribution from Dick. He wants to enjoy my mother's property with Scholar and their children in my brother, and I have grown up very difficult circumstances. I know that my mother maintained a saving account worth Uganda shillings. She also owned land at Chamugorani village. She owned 5 acres of land at Rwenshenyi in Bushenyi, which coffee plantation and a banana plantation. Facts for Dick Bunyuga. My name is Dick Bunyuga. I am a widow. My wife Rose Asimwe died. I had 2 wives and Scholar Abiona. Now I have only Rosen did not give anyone child. I dearly loved her. She allowed me to marry Scholar. I'm the widow closed with authority, moral, and legal to manage the property of my deceased wife. So basically here what we can see is that someone lodged a petition and someone is objecting that petition. So we have here the petition, humble petition of Bunyuva. We can see it there, deceased, estate, next chassis of photocopy of the marriage, we can see there. I obtained a certificate of no objection from the Inspector General. So petition verified. Then from there we can see declaration, and also we can see notice of application, as well as notice of application, as well as we also have the petition on Musa Musango. Petition on Musa Musango, letters of administration, which we are granted. So basically those are the documents. Basically this month we shall be having a suit arising out of lodging a caveat on granting of the petition. So basically that was it for this discussion. Please subscribe, like, comment, and share. And in case you're interested in a mastermind group, please contact me on 075 6767 284. 075 6767 284. Please subscribe, because here we analyze all the workshops of both intakes, and then we also bring you oral tips. So it's really to your advantage to subscribe and turn on the notification button so as you don't miss any update. Otherwise, I wish you success in the family week. May you please God grant you the wisdom to excel and pass the IA.